Hi, I'm Bridget Barrett, and welcome to the World of Whistleblowers, a show that dives into the wide world of whistleblowing, featuring up-to-date news, analysis commentary, and emerging trends. I'm here with my co-host, Jason T. Brown, head of the whistleblower law firm Brown LLC, and a former FBI special agent and legal advisor. Good to see you, Jason.
Hi, Bridget. Happy to be here with you on the World of Whistleblowers. It's certainly exciting times, and it's very exciting times for whistleblowers. Now that Congress has finally prioritized whistleblowing and incentivized individuals properly, over the last couple decades, Bridget, whistleblowers have gotten billions of dollars in whistleblower rewards for doing the right thing and coming forward with information in the right way. So we definitely have a lot to talk about.
Well, I'm sure with billions, that's definitely going to get a lot of people's attention.
I'm sure it will too, but it can't just be about the money. There have been billions of dollars that have gone to whistleblowers, so there's been high rewards, but there's been high heartaches to people who tried to blow the whistle the wrong way. So at the end of the day, it really depends upon people who want to do the right thing and make sure that they're not suffocated by swimming in a stream of fraud and looking for an escape route. It's another angle for them to try to blow the whistle besides the economic portion of it.
Jason, as a former DOJ, and now that you run a firm that was ranked by Lex Machina as the second most prolific whistleblower law firm in the country, why don't you tell us a little bit about the False Claims Act?
Well, the FCA, the False Claims Act, dates back to the Civil War, and it had to do with people defrauding the government in its time of need when there was limited resources. So Congress passed a law, the False Claims Act, also known as the Lincoln Law because it was enacted under Abraham Lincoln, that incentivized individuals to come forward, reveal the fraud, and in turn receive a portion of what the government itself collects in the litigation. The concept, even though in America started during the Civil War, dates back to the days of the king, when there used to be feudal systems in England. And that's why the proper Latin term is a quitem. It's an individual that brings a matter on behalf of the king as well as his or herself.
Okay. Well, take us out of feudal times if you could and bring us back to the present day.
Yeah, it's probably better not to talk about feudal times and talk about the False Claims Act today. The False Claims Act today really deals with when entities defraud the federal government, and it happens in a variety of ways. Generally, the federal government is an entity itself, but it's the taxpayers' money. It's the government's money is the taxpayers' money. And individuals can defraud the taxpayers, defraud the government in a multitude of schemes. And the most prevalent ones are generally in Medicare fraud because there's such a big healthcare budget, Medicaid fraud, TRICARE, another government health insurance program, customs fraud, pharmaceutical fraud, which is also a subset of Medicare and Medicaid fraud, defense contractor fraud, huge space. If we know, I don't want to take us back too far, but in the 80s, the government used to pay like $1,000 for a screw. And that's literally and figuratively over the years that would occur. So now there's all sorts of things like Truth in Negotiation Act, things to make sure that the government isn't defrauded in the defense contractor space. Pharmaceutical fraud that we just mentioned also intimates kickbacks, also kickbacks in the defense contractor space. Kickbacks involve when somebody pays something above fair market value or anything at all to induce business with the government and doesn't properly disclose something along those lines. You also have customs fraud. You have an emerging area there where people are evading tariffs. They're drop shipping, particularly goods or products from China where they're concealing its true origin and making cosmetic or superficial changes in a different country to avoid the 25% levy. And with the pandemic, you just recently had PPP loan fraud and COVID fraud as two big priorities for the government to try to hit with the False Claims Act.
Well, that's certainly a lot to digest. What sort of whistleblower rewards are there for someone under the FCA?
Well, each year for the last decade or so, there's been $2 to $3 billion recovered under the False Claims Act. And under the statute, the whistleblower is entitled from 15 to 30%. And to further delineate it, it's 15 to 25% if the government intervenes and 25 to 30% if the government does not intervenes.
So people would think then that based on that information, it's better for the government not to intervene. Is that correct?
You would think, because you do get a greater percentage. But when you start thinking about it and going over the law of averages that hold, if the government intervenes in the case, the typical or average settlement value is around $13 million. If it doesn't intervene, the typical settlement value is around $3 million. Also want to drop a footnote, plenty of things just don't settle or go south. But you can see you can either get 15 to 25% of the average of $13 million versus 25 to 30% on the average of $3 million. And you got to ask yourself, which one would you prefer to have at the end of the day?
Well, math always wins. Why don't we go over the difference between an intervention and a non-intervention?
That's really important, and that's why it's really important to select a whistleblower law firm that has substantive experience in the False Claims Act, a firm with Department of Justice experience, because they're the ones, also the Department of Defense may be making some of the decisions whether to intervene or not. An intervention determines whether or not the government itself, who's presented with the case confidentially under seal under the False Claims Act, is the one who is going to be in the driver's seat steering the litigation. They look it over, they investigate it while it's confidentially under seal. If they think there's something there, more likely than not, they try to take that from end zone to end zone themselves, meaning that they are intervening, they're handling the case. At a certain juncture, generally 2 or 3 years down the line, could be more, could be less, they decide, yeah, there may be something there, but we don't have the resources to litigate it ourselves, or it's too low of a dollar amount for us to litigate. They're going to not intervene. They're not going to be at the driver's seat of the case, and they will turn the keys over to your whistleblower lawyer, your whistleblower law firm to handle the matter and litigate it like a normal lawsuit. However, since the government has province in the matter, they could demand you dismiss the matter, which is a current topic that went to the Supreme Court, that even if the relator, the plaintiff, objects to the dismissal, most likely the matter will be dismissed.
Well, Jason, thank you so much for this insightful episode. I'm sure our listeners will have a lot of questions. Leave your comments in the comments section below, and we'll see you next time in the next episode of The World of Whistleblowers. Thank you.